You are now listening to the Fighting Back podcast, and here's your host, Jessica Travis.
Welcome to the Fighting Back podcast. Today's episode is all about child support, how it's established, how it can be changed, and what happens when it isn't paid. Joining me today is fellow attorney and child support expert Annie Rodriguez-Newbern from Tango Rodriguez and Associates. She represents the state of Florida Department of Revenue Child Support Enforcement. Her firm focuses on child support establishment, modification, and enforcement, and regularly works with cases involving the Florida Department of Revenue. Annie, welcome to the show.
Thanks, Jessica. I'm really excited to be here. This topic affects so many families, and there's a lot of misinformation out there.
So let's start with the basics. When people hear child support, they usually think of a monthly payment. Legally speaking, what is child support in Florida?
Well, child support is a legal obligation. Both parents have to financially support their child. In Florida, child support is calculated using statutory guidelines found in the Florida statutes. And really the goal here is to ensure that the child's needs are met in a way that reflects both parents' incomes.
And it's not just income, right?
Right. The calculation takes into account gross income for both parents, the number of children, health insurance costs, daycare expenses, and how much time each parent spends with the child. The formula is designed to approximate what the household would have spent on the child if both parents were still together or together to begin with.
And this applies whether the parents were married or never married?
Exactly. Marital status has nothing to do with it. It doesn't change the child's right to support. Child support can be ordered in divorce cases, paternity cases, and cases where the parents were never in a relationship at all.
A lot of people hear Department of Revenue and think taxes.
That's right.
What does the Florida Department of Revenue actually do in child support cases?
So the Florida Department of Revenue is a state agency. They have a child support program, child support enforcement program that helps establish, modify, and enforce child support orders. Their role is to make sure children receive financial support and to reduce reliance on public assistance.
So who usually ends up with a DOR case?
It's a great question. Often parents who apply for child support services, parents receiving public benefits, or parents who can't afford private counsel, those are the people that typically end up with a DOR case because DOR can help establish paternity, calculate child support, and bring on enforcement actions.
So one important distinction I heard you mention is representation.
Yes, that's a big, big deal. The thing with representation is that DOR attorneys from my office, do not represent mom or dad. And that's a very common, very, very common and sometimes frustrating distinction there.
I have heard that. My clients will come in and they'll be like, oh, I already have an attorney. And I say, you don't. It's the Department of Revenue. They don't represent you.
Right, or they'll call our office really frustrated saying, but you've been appointed on my case. Well, the Department of Revenue hires our firm in Orange County specifically and other law firms and attorneys throughout the state to represent specifically the state of Florida in a case. We can't give legal advice to either parent. We can make recommendations based on what the Department of Revenue sees. And the attorneys strictly focus on support. So issues of custody or time sharing, we don't have the authority to really give any kind of advice or opinion about those issues.
So the parents still have the right and sometimes should hire their own attorney?
Absolutely. And we like to remind the attorneys, too, we don't mind getting involved in your cases because we are very strictly looking at the issues of child support. So in the complicated cases, like when someone is self-employed, so income's a little more difficult to calculate or income is disputed because there's things here and there that might affect that, private counsel or someone to represent you can be especially helpful.
Well, let's talk about now how child support actually gets established.
Oh, man. Well, there are a couple of ways to do it, but the two main paths, one is through a court case, like a divorce or a paternity action, and the other is through the administrative process. Those cases go through the Division of Administrative Hearings, or you might hear that called DOA.
What's the practical difference between the two?
So in court, in that court case, a judge, a magistrate, or child support hearing officer is going to be the one hearing your case. But in the administrative side of things, DOR prepares a proposed administrative support order and will send it to you. You then have the right to request a hearing before an ALJ, what's called an administrative law judge. But if you don't request a hearing, that proposed order becomes final. Both types of child support orders are legally enforceable, but in a circuit court case, you're going to have that trial. You're going to have the presentation of evidence, or you're going to go to mediation. We're in that administrative arm, that administrative side of things. You might just get an order issued to you if you don't assert your right to a hearing.
And what does the process usually require in terms of what's needed?
Oh, wow. There is just so much. So financial affidavits, proof of income, tax returns, W-2s, 1099s, any documentation of expenses like daycare or health insurance, that all of that information comes together and is used to run the guideline calculations.
And paternity, that has to be established first if the parents weren't married.
Correct. So no child support order can be entered unless paternity is established. That can be done a number of different ways, and I feel like that might be a topic of another podcast because we could go on about that.
We will definitely talk about that on a different podcast. But one of the common questions that I do get from my clients and from others in the community is, can I change my child support once it's already ordered?
And the answer to that is absolutely yes. The issue here is it has to be a substantial and permanent change in circumstances.
Okay, so let's talk about those two words because I feel like those are buzzwords.
They really are.
What is a substantial and permanent change in circumstances?
Well, let's see if we can come up with some examples.
Okay.
So you've lost your job, no fault of your own. You've gotten a significant raise, would be amazing, right? Or a pay cut, on the other hand. Or maybe something you see in your cases, like a change in time sharing or some medical issues for the child or children or for yourself. So those would be examples of permanent changes that are substantial. Not, my child decided to go over for a week at their other parent's house. That's not exactly a substantial change. Or if I'm out of work for a week or two, that's not a permanent change. That's an example of something that's just happens and you'll bounce back real fast.
Okay. So say there is a substantial change in circumstances. Can DOR help with modifications at that point?
Absolutely. Yes. And we love modifications because if something changes, you're owed a modification. The Department of Revenue has a review process as well. It can be a parent requests a modification, or the Florida statutes actually require a review automatically every 3 years. So those are two ways that a modification can come up.
So every 3 years, the Department of Revenue is already reviewing the cases to see if modification is necessary.
That's correct. You might not necessarily see it happening because it happens in the background, and you might get contacted if they think you might be due a modification. But if they're looking at your taxes, they're looking at the stuff that they see, and they think we don't know of any substantial permanent change in circumstances, they're not going to send it for one. So I definitely would recommend that anyone out there who thinks they're owed one or might need to consider it, reach out because the Department of Revenue can review a case.
Now, when I talk to some people, a lot of times what I hear them say is that they've agreed to change support informally between each other, even though there's still a support order out there. What do you think about that?
We see those informal changes in support, and they're so risky because until there's a court order that modifies another court order, the original amount is still owed. So those informal agreements don't protect you from an enforcement later. And on top of that, if you're paying outside the system and you've been ordered to pay it through the system, you're not going to get credit for that. So save yourself a whole lot, and let's make those informal agreements a real court order to make sure that modification is tracked by everyone.
You just mentioned something big. Enforcements.
It is big.
So let's talk about enforcements. What happens when support isn't paid?
Man, well, Florida has strong enforcement tools. The Department of Revenue can issue income deduction orders, income deduction notices, income withholding orders. They're all kind of the same thing where they send a notice to your employer to make sure that money gets taken out of your paycheck before you even see it. but they're also intercepting tax refunds, suspending driver's license and professional licenses, fishing licenses. They can submit to the State Department to have passports denied, and they can pursue contempt proceedings.
And when you say contempt, you mean jail time.
There's always that opportunity for jail time. And yes, in extreme cases, we've seen people go to jail with a purge. And what that purge means is that there's an amount that the hearing officers or the judges are going to review a case and say, you have to pay this purge to get out of jail, because the goal is compliance and not punishment. You have to have the ability to get out of jail, so that purge is supposed to give that to you. And because the court doesn't have the power to impose that punishment. This is civil. This is not criminal.
Those are really serious consequences, though. And I know there has to be times and situations when someone truly can't afford to pay their child support obligation. What happens then?
Well, that's when we look at people and say, file for modification immediately. Don't wait. Let someone know. We joke that Big Brother is watching or listening, but in reality, the state of Florida, the court system, your other on the other side of things just may not know what's going on. So if you don't let the court know, if you don't request that modification, they're not going to know, and they're going to hold you accountable to that court order. So, and arrears interest, the interest accrues in the state of Florida. Now, the Department of Revenue has no interest in the interest, but that's going to affect so much in your life. It's going to affect whether or not you can rent an apartment, whether or not you can get a house. It can affect whether or not you get that next job. So you really want to make sure that if there is a real reason why you can't make those payments, you're notifying the Department of Revenue, the person on the other side of your case, and the court.
This has been some really good information. I do want to try to clear up some common myths that I hear often. So the first one is, if I don't see my child, I don't have to pay child support. What about that?
Oh, that is the big false one right there. That is so false, because child support and time sharing are legally separate. So you can't withhold paying support because of visitation issues, and you can't withhold visitation because support isn't paid. It's that way for both parties.
Okay, I've got another one, and we briefly mentioned it before, which is I have an attorney. The attorney that works for DOR is representing me.
We are not public defenders. We are not state attorneys. We do not represent people. So as attorneys who represent the state of Florida Department of Revenue, we do not represent either parent. But that doesn't mean we don't welcome when you reach out to an attorney to seek their services.
And another one, me and the other parent have already agreed on an amount, and we've agreed that we are paying each other, so we don't have to go to court.
Oh, that is so wonderful, especially around the time with the season of love, Valentine's in the air, and you've made up your minds that you can work it out, and that's great. So the first thing I would say to that is go to the Department of Revenue and close your case if you have one.
Okay.
But like we were saying before, if you don't tell anyone, you run the risk that no one knows what you're up to. So get that order to modify a court order, and if you're going to do anything later on, if you want to hold that other side accountable for making those payments, you want to make sure that you have a court order that takes your agreement and makes sure that it's enforceable in the future.
Wow. Annie, this has been incredibly informative. Do you have any final advice for parents dealing with child support in Florida?
Well, it can be daunting. It can be really scary to have the court system involved, but I would recommend know your rights. Know your responsibilities. Don't rely on assumptions or informal agreements. And whether your case involves DOR or not, know that there's a legal process in place to establish and modify support, enforce support, and at the end of the day, anyone can ask DOR for assistance in their cases.
And remember, the system is designed to support children, not punish parents. If you're involved in a child support case, especially one involving the Florida Department of Revenue, understanding the process can make a big difference. Annie, thank you so much for joining me. I really enjoyed having you here today.
Thank you so much, Jessica, for having me.
Thank you so much for listening. If you found this episode helpful or informative, don't forget to follow us on social media and share this podcast with your friends. Like, follow, subscribe so you never miss a show, and help others know their rights by spreading the word. Your support helps us keep fighting back. The information provided in the Fighting Back podcast is for general informational purposes only and is not intended as legal advice. Every case is unique and should be reviewed by a qualified attorney who can provide guidance based on the specific facts and circumstances of your case. Listening to this podcast does not create an attorney-client relationship with Fighter Law or any of its attorneys. If you are facing any legal issue, we strongly encourage you to consult with a licensed attorney directly.